Hi, I'm attorney Samantha Gordon with McIntyre Elder Law. Welcome to the Elder Law Report.
Hi, I'm Jane Dearwester. I'm based in our Hendersonville office, and we're here today to talk about adoption and how that affects estate planning.
Yeah, so specifically dealing with estate plans and adoption. So if we have individuals that come in and we're talking about an estate plan and we're going over, how many children do they have? Do they have grandchildren? And then someone mentions to me that they have an adopted child. Well, adopted can mean multiple things to multiple people. It can mean that you've taken in a child, but maybe not legally adopted them. But so you do consider them your child, but under the law, if you do not have an estate plan in place, then they actually are not considered your heir at law. So really distinguishing between legal adoption and then, taking in someone as your child, two different things within the law, especially in our area of law. So if a child is legally adopted, then they are your heir at law. And if they're not, then you want to ensure that you have an estate plan in place so they can be considered a beneficiary of your estate plan. That's really kind of the quick down and dirty of adoption, specifically for estate planning. And then we also run into sometimes a situation where we're opening up an estate for an individual doesn't have an estate plan. And there is a child that, comes into the picture and says, hey, I'm a biological child of this individual, and I want to be included in the estate. Well, actually establishing paternity in North Carolina, there are specific steps that need to be done. And just having a birth certificate where a father had signed that birth certificate establishing paternity does not mean that that individual automatically is considered a biological child of that father. There are specific rules in our laws that actually determine that. Even if, say, for example, this individual signed your birth certificate, they put themselves out to be your father your whole life, there has to be specific ways within our laws that actually establish paternity, unfortunately. So it's very important to know that. And by having an estate plan in place, this really avoids this whole establishing paternity and making sure that this individual is included within your estate. So having an estate plan, you can have that person included in writing on paper, and then they'll be able to benefit from your estate. So to establish paternity in North Carolina, there's three different ways. So the first way is there's some type of criminal prosecution of a parent for non-support of a child. So some type of order for child support. Two, a civil action to establish paternity that had been brought on, and a court actually ruled that this individual is in fact the father. And then three is declaring the child legitimate. So that also is going to be an order from the court legitimizing that child as the individual, the child of that person. So making sure that if this does come into play, if you do have a child, that this is specifically also a child born out of wedlock. And that is a very old term that North Carolina still uses. It just means a child born out of a marriage. And so making sure that, if there is a situation, if we have a blended family, if there's a child that's not part of your current marriage, really ensuring that you have an estate plan that really is going to establish what you want to happen with your estate and include everybody that you want to have included. And, that can get really tricky within the estate planning world as well as the probate world. But then we also have recently, it's become really relevant, the LGBTQ community, Jane, and really focusing on, how can all of that work also within their estate plan if, there's donors and same-sex marriages, and really making sure that, those individuals protect themselves as well as their children.
Yeah, definitely. And correct me if I'm wrong, but establishing paternity, I think if I remember right, that has to be done during the father's lifetime.
Correct.
Because we had a case come up. We actually had some people come in asking about it, but the woman's father had been dead over 10, 15 years. And I had to do a little quick research, but I said, I don't think we can do it now. I don't think we can establish paternity, even though there was some DNA test or some kind of, medical test that existed. The fact that the father had been passed away for over a decade, there was no way we could help this person. And certainly going back to the LGBTQ issues, before same-sex marriage was legal in all 50 states, there were all kinds of very special considerations that same-sex couples had to go through. And now it's a maybe a little bit easier, but there are still some issues that come up, particularly for the non-biological parent. So in a couple, most of the time, or sometimes not, the non-biological parent needs to get an official adoption decree so that they are legally the parent of this child. And the birth certificate, even though they may write the two individuals, even if they're married or not married on the birth certificate, that's only a presumption of parentage. It is just not the same as a court order. And that can come up, on a variety of issues. Another issue that came up in this realm of LGBTQ estate planning was there are documents called a voluntary affidavit of parentage. There are also co-parenting agreements where you could spell out basically by contract or by a written verified document that these are our wishes and we treat this person as our child, but neither of those documents, the voluntary affidavit of parentage or the co-parenting agreements, neither have the same force and effect as a court order. So you want to get an adoption decree in place. And once you have it in one state, thanks to full faith and credit of the U.S. Constitution, that's going to be enforced in any state where you might move or travel. Another item for LGBTQ families, a suggestion in a recent seminar I attended was to have written consent for medical treatment if the non-biological spouse is transferring the minor child out of state for medical treatment. That's just another thing to be heads up on. And it's why we ask so many questions in our consultations. We really want to know who your heirs are, who you want your heirs to be. I even had a case last year that involved an adult adoption. So this woman was actually our client's ex-wife, and after she and our client got divorced, his mother adopted her as an adult. Wow. Yes, it was a very interesting case because mom wanted ex-wife to inherit, and she thought that was the absolute best way to make sure she inherited. And guess what happened? We end up in litigation for about 2 years over all of it. And so it is a thing, and it certainly solidifies inheritance. That's what the litigation was about, because she, by law, absolutely, she was legally adopted. She was an heir at law. But as you can imagine, our client was not so happy since his ex-wife is now his sister. So on that note, that was a very interesting, unusual case, but it really shows how adoption can affect your estate plan in some very interesting, unusual, maybe unpredictable ways.
Definitely. Thanks, Jane. Appreciate that. If you have an estate plan in place and maybe you haven't considered this aspect, or you don't have an estate plan in place at all, you could definitely give us a call. We would love to discuss that with you. Our telephone number is 888-999-6600, or you can actually go to our website and schedule a consultation at mcelderlaw.com/scheduling. Thanks, Jane.
Thank you.
Bye.
Bye.